I am attorney Amanda Shaffer. Welcome to Notable Approvals. I have a very interesting update on a case to talk about today. A case I talked about actually back in October of 2020, back in the long ago before the COVID. But before I get to the case today, a couple quick announcements. First, if you like what you see, find it helpful, know someone who will, please make sure to share it. Hit that little share button. Also, make sure to like us and follow us on Facebook and YouTube and Instagram, wherever you are watching us, so that you don't miss another notable approval. And check out all of our other notable approvals and helpful and informative content on immigration, family, and other types of law. So today's case is about a case that I actually started talking about in October of 2020, as I mentioned. And it is a case of that a naturalized U.S. citizen from Sierra Leone. She has 3 children. At the time, one was an adult child who was unmarried, and the other 2 were minor children, actually twins. And she filed for all 3 with another lawyer, and then had came to us because they had been denied. And she first filed them, I think, for 2018. So I'll give a quick recap what happened, because we are going to focus on only one of the 3 children today, and that was the last one we were waiting for an approval on. So all 3 children, she had problem getting approved, essentially because there was issues with her not including the children on her immigrant visa application, which, if you've seen other notable approvals that I've done, that can be a big problem if when you're filling out your non-immigrant visa or your immigrant visa application, or any immigrations applications for immigration for that matter, and you leave off family members, and then you later want to file for them to bring them to the US or get them a green card, you're going to have a problem with USCIS. They're going to say, well, why weren't they on there in the first place? Are they really your child? Even though you're like, they've given you their birth certificate. So when she came to us, she hired us to write a letter and explain to immigration when they sent the notice of intent to deny that, look, she made a mistake. She had someone help her. It wasn't filled out properly, but unsurprisingly, USCIS still denied it. So we refiled for all 3 children again. And this time around, there was an issue with the birth certificates. So basically, and this happens in a lot of countries, I think it even still happens today. Actually, I know it still happens today, depending on where you live, especially if you live in a more remote area, that birth certificates, marriage certificates, divorce certificates, they don't always get registered at the time the event takes place. So you have a child, your child's born today, and it might not get recorded for a number of years, number of weeks, days, whatever it is. The longer it takes for it to get registered, the more likely the US is going to question it. So what ended up happening is that USCIS said, well, we don't, even though generally when you're trying to prove a relationship between a mother and a child, it's easy because you submit the birth certificate showing the mother gave birth. The US, in this situation, for all 3 children, the US sent a request for more evidence saying, well, not only do we know about what happened in your previous application, them not being on the birth certificate, you didn't register these birth certificates for years. So we had to submit proof of that this is actually her mother. Well, what's the easiest way to do that? Get a DNA test. And if you're going to do a DNA test for immigration, you have to do it through one of their approved ways. And in this situation, none of the children were in the US. The client was in the US, but the children were back in Sierra Leone. So we sent them to do the DNA tests. Oh, I forgot one important thing. The child that we're going to talk about today, we took a slightly different path, and I'll get to that path in a second. We didn't do his DNA test right away, as we did with the other two. So the other two children, which was the adult child, the adult daughter, and the minor son, who is the twin of the other child I'll talk about in a minute. They did their DNA test, they got it back, and the cases were approved. And when you get a request for evidence, you have a certain amount of time that you have to reply by, no matter what. So we couldn't do the DNA test immediately for the other child or the twin, because whoever was helping the client before she came to us, I think it was either an organization or an attorney, for some reason they appealed the denial of the first alien relative petition or I-130 petition. Even though, again, same reason, the late registration of the birth certificate, not being on the immigrant visa application, and her non-immigrant visa application. And that appeal was dismissed, not surprisingly, but the main reason it was dismissed was actually because there was no brief submitted. So we had to refile his even later than we refiled the other ones. So we refiled his, and then he had the DNA test. Wait, let me go back up to my notes up here. Okay, so that's when he came to us. I mean, she came to us after the BIA, after the BIA started. This is like a long history. I'm getting myself confused here. Good day, Tanya. Thanks for watching me get all confused, but I think I got it from here on out. Now that you're here, you're very helpful. So basically what ended up happening, the other two children get approved in 2019. I think they are actually already in the US, although there may have been a delay from COVID. But bottom line is we had to reapply for the other son, who was the twin of one of the children who's already approved. So it gets denied in late 2020. In 28. Oh no, the second one was denied in late 2020 due to abandonment. We did apply 3 times. I'm on it now, guys. I'm on it now. All right. So the first one was denied, and then it was appealed for some reason, and denied. The appeal was denied because there shouldn't have been appealed in the first place. No brief was filed by the previous attorney. Second one gets filed and gets denied because they don't believe that she was the mother because of the late registered birth certificate, even though we sent the letter, we explained it, and all of that. And then we also we applied for all the children to get. 2 of the children get approved, the third child does not. And they then had like another issue with the birth certificate or something with the third child. Again, it was a twin, and that's why I think this case is interesting for so many reasons. But one of which is that I have clients who come in and say, well, my friend had the same case as me, or my sister, or my brother, or my child had the same case as me, whoever it was, and they got approved, and I did the same thing, but it didn't get approved. And we always tell them you can't go by what happened with other people. And this is a perfect example. In my professional opinion, I have a lot of expertise here. I've done a lot of these. There's no reason why the other child shouldn't have gotten approved at the same time, but it happened and we had to deal with it. And appealing it isn't always the best decision or the right decision or going to do anything. Sometimes it's just a waste of time and money. So in this case, we're like, okay, we need to reapply. So we refiled. So in late 2020, it was denied due to abandonment. And the reason it was denied, that was the second denial. USCIS sent a request for evidence for this child, the last one that I'm talking about today, for a DNA test. Again, we don't believe that you're the mother. We need a DNA test. So we get this DNA test request in April of 2020. She goes to do the request in in April of 2020, she gets the request. Less than a month later, in May 2020, she goes and her son goes and they do their DNA test. You have 87 days to respond to an RFE unless you request an extension. So as we're waiting and we're waiting and we're waiting for this DNA test result, of course, as you know, we're now in COVID because it's 2020. We're right in the heart of COVID. And the lab, we're calling the lab, we're trying to find out what's happening, and they're like, look, we're really delayed because of COVID. They had to shut down. We'll give you a letter to send to USCIS to ask them to extend the time. And we did just that. But USCIS didn't care and ignored the letter and denied it. And the reason stated in the denial was due to abandonment. And that was quite frustrating, especially because my client was excited to have all of her children finally here with her. So after it was denied, and this was in October of 2020, we refiled it for, I think it's the third, not the fourth time, but the final time. So we finally refiled it May 2021, and this time we sent it in with the birth certificate as well as the DNA results that we finally got back in 2021. And it was approved last week. So that means about 6 months later, it was approved, no request for evidence or nothing. And because it's a minor child of a U.S. citizen, there's no wait time for a visa. I already got the case creation notice from the National Visa Center to start the process of bringing him over here, which is called consular processing. And once he enters the U.S., he will be a lawful permanent resident. And finally, this lovely lady that we have known for years now will have all three of her children here with her. So this was quite, I call these sometimes marathon cases. I didn't qualify it this time as a marathon case only because there were three separate people involved, even though they really should have all been treated in the same way. And we had the same problems with all three of them, yet the timelines didn't match up. Even the daughter and the son who were approved first, there was like a month in between approvals and then months in between the times that their case was created with MVC. COVID got in the way for sure, but it was really frustrating when the case got denied because the DNA test results didn't come back in time, despite the fact that our client, she was on top of it. Her son was on top of it. We would have gotten it to USCIS as soon as possible. We even notified them when we knew it was going to be late. But unfortunately, sometimes that's just the way it is. But Hi Lambert, thank you for watching. I try to keep track of our I think you could show these on the screen too. I don't know with Instagram still. But anyways, I try to say hi to everyone who says hi. But anyways, the point is that this is a great example of why you should never give up. If you have a case that should be approved and can't always tell you it should be, we can tell you that there's a good chance or it depends. This is a case where this is clearly her child and she's clearly eligible to get an immigrant visa and come over here and be with his mother. And this woman, she's not a woman of means. She's a very hardworking, sweet lady who just kept trying so that she can have her family together. And that's finally what's going to happen. We got a little bit more of the process to go, but that was the hard part. It's usually not the hard part when you have the mother involved, but it was here. That was the hard part. Now we go through the consular processing, and really within a few months he can be in the U.S. and that will be awesome. And I will definitely put up a little update once I can finally, hope maybe I'll even, if the family consents, get a nice little family reunification picture, because that to me is one of the main reasons I do my job for moments. Well, not main reason, that is the main reason I do my job for moments like that, to really bring a family back together. It makes me really happy and justifies how hard I work and how frustrated I get sometimes with the government and how they handle these things. But we did it. He's going to be here, and that is really all that matters at the end of the day. So that is all today for notable approvals. If you found this helpful, you know someone in a similar situation, or you yourself are, please hit the share button so that other people can find this information as well. And also don't forget to like us and follow us on Facebook and YouTube and Instagram, wherever you get your Shapiro Law Firm social media information. We have a quick question about this from Juan. He's asked, will he receive citizenship once admitted to the U.S.? Juan, that's a great question, and thank you for watching. And to answer your question, he will first receive his green card. And that is because with very few circumstances, which is for another day, and you can look, I do have videos about automatic citizenship or after birth acquired citizenship. That's not what this is. So in this situation, he will first become a permanent resident, and then in 5 years from the date that he becomes a permanent resident, he will, well, 3 months before the 5 years, he can first apply, but the 5-year mark, he will be eligible to apply for U.S. citizenship. And as long as he has good moral character, the physical presence, continuous presence requirements, there should be no reason that he will not get his U.S. citizenship at that point. Thank you for that question. That was a great question. And that's true of anyone who brings over a U.S. citizen relative, again, with very few exceptions, which you can search our videos to where I talk about N600s, certificates of citizenships, after acquired citizenships, automatic citizenship, derivative citizenship. Those are the terms you can search for. That's the only time that there's really an exception. And even some of those require you to first enter the U.S. as a permanent resident. It's just the question of the process of whether you have to formally apply through what's called an N400 or naturalization, or if you're already considered a U.S. citizen and need to actually prove it. But if you're bringing over a family member, whether it's a child, a sibling, a parent, or a spouse, they're going to, and whether or not you're a U.S. citizen or in certain family relationships a permanent resident, they will enter as a permanent resident as well, but on their own right will be eligible for citizenship. So thank you again for that question. Any more questions? Know anything, any situations that are similar? Leave it in the comment section below. Shoot me an email or give us a call. Our contact information has been scrolling across the bottom of the screen on Facebook and YouTube, and on Instagram. Go to our bio and you'll find it there. So thank you all for watching and have a great day.